Everyone, my name is Borzu Sabahi. I'm a partner at the law firm of Mallet Prevost, Colt Mosle LLP in Washington, D.C. I'm also an adjunct professor of law at Georgetown University Law Center and co-director of the ILI's International Investment Law Center. I am grateful to CTIL for inviting me to speak in this workshop and allowing me to be present via video recording. The topic assigned to me is International Investment Arbitration, a Global Perspective. I address it in 5 parts. 1, I will cover overview of investment treaty framework and ISDS. 2, global experience with ISDS. 3, the backlash against ISDS. 4, global reform initiatives. And 5, India's place in this context. So let's start with the first one, overview of investment treaty framework and ISDS. As a matter of introduction, as of March 2019, countries around the world have entered into about 3,500 investment treaties. The majority of these treaties are bilateral investment treaties or BITs. In addition, states have entered into a large number of other investment agreements, mainly in form of investment chapters of free trade agreements. An early example of such investment chapters is NAFTA Chapter 11. More recent examples include Canada-European Union Comprehensive Economic and Trade Agreement, so-called CETA, and the Trans-Pacific Partnership Agreement, TPP, which after the withdrawal of the United States became known as TPP-11. And of course, ASEAN Comprehensive Investment Agreement is another one. Several other major regional agreements with investment chapters are under negotiation. These include the African Continental Free Trade Area and the Regional Comprehensive Economic Partnership, or RCEP. Most of these treaties have investor-state arbitration or ISDS provisions, which enable foreign investors to directly sue host states of investment before international arbitral tribunals. These tribunals are constituted under supervision of ICSID and other arbitral institutions. ICSID stands for International Center for the Settlement of Investment Disputes and is an arm of the World Bank. Investors under most of these treaties don't have to go to local courts anymore. As long as they can find an applicable treaty, they can sue host governments under the treaty. The early investment treaties, however, were not tightly drafted and were not tested. Governments often perceived signing bids as a good photo op without recognizing the consequences of obligations in those instruments. You give a loosely drafted text to a group of creative lawyers and you can imagine what comes out of it. Lots of ISDS cases. Although the first bids were signed in late 1950s and early 1960s, the bulk of the ISDS cases have only taken place during the past 20 years. This is a young field in a sense and is still evolving. These cases have been mainly commenced by corporations from North America and Europe. More recently, however, a number of investors from developing countries are using ISDS, signaling a paradigm shift. The second point, the global experience with the ISDS. Let me get to more details here. Several companies, particularly in recent years, have managed to obtain very large damages awards in these arbitral proceedings, ISDS proceedings, exceeding $1 billion or more. These are the so-called mega cases, to borrow George Kahale's words. You all probably have heard of the claims of Yukos shareholders against Russia. They wanted more than $100 billion. The tribunal awarded them $50 billion. That award was set aside in The Hague, but legal battles surrounding it has been ongoing since 2004 when the claims were filed and I believe continue to this day in various courts around the world. It hasn't been all loss for governments, though. In fact, the statistics suggest that governments win a bit more than foreign investors. However, overall, the experience of many governments with investment treaty arbitration has not been exhilarating across the board. Advanced economies of the world were initially very excited about this overall and novel mechanism of ISDS. They perceived it as a powerful tool or protection mechanism at the disposal of their investors. But that perception quickly was replaced by a sober realization that this new tool cuts both ways, and the advanced economies are likely to find themselves at the defendant's seat as much as the developing countries are. A watershed in this context was probably the series of early NAFTA Chapter 11 cases in the late 1990s and early 2000s, which were filed against the United States and Canada, two advanced economies. The idea that these countries would become targets of several mega arbitrations was not probably in their contemplation when they negotiated the NAFTA. Rather, they thought Mexico would be the main target of ISDS claims. The experience of the last 2 decades shows that they were wrong. ISDS has not spurred other advanced economies either. Several European countries have been sued: Spain, Czech Republic, Germany, Italy, to name a few. In Asia, China, India, and South Korea have been defendants in a number of cases. Overall, however, developing countries of the world have been defendants more than the developed bloc. South American countries, particularly Argentina, Ecuador, and Venezuela, have been hit by numerous mega arbitrations relating to their extractive industries. Some observers are bothered at the idea that tribunals composed of 3 private arbitrators hear cases against sovereign states. More troubling for them has been the notion that these tribunals may second-guess policies of states and decisions of national courts under principles of international law. ISDS cases, in fact, often deal with governmental measures involving matters of public health, environment, taxation, banking, and so forth. These are areas in which sovereigns often would like to enjoy a margin of discretion to fulfill their public function and duties. I'm sure you're all familiar with the Philip Morris cases against Uruguay and Australia. In those cases, Philip Morris challenged government measures meant to protect public health against consumption of cigarettes. Philip Morris lost those cases, but the idea that such measures could be challenged in arbitration was appalling to many. Other areas of concern with the modern ISDS include the amorphous nature of some protections in investment treaties, particularly the fair and equitable treatment, which investors have been trying to continuously expand. This is the so-called FET protection. Inconsistency of arbitral awards interpreting similarly worded treaty provisions such as the most favored nations clauses and umbrella clauses has been another issue. Investors' parallel pursuit of ISDS together with commercial arbitration and court proceedings, another problem. Treaty shopping practices where investors set up or use shell or other holding company solely for the purpose of bringing ISDS claims. Third-party funding, a new phenomenon which enables foreign investors use outside funding to bring ISDS claims. This is another problem. Concerns regarding ethics, conflict of interest, impartiality, and independence of arbitrators, including the so-called double hatting problem, where arbitrators serve both as counsel and arbitrator at the same time in related ISDS cases. And of course, lack of diversity in the pool of arbitrators is an issue. These arbitrators, as you may know, mainly come from Western Europe and North America, and they're mainly male. Last but not least, the size of the claims, the mega case, relative to the GDP of the small countries has been raised as a problem. Let me get to the third point, the backlash against ISDS. Mounting criticisms of the system of the ISDS from both developed and developing countries, as well as from civil society groups, has triggered a backlash, leading to a number of reactions and adjustments to the system. And I'm going to cover some of them here. Several countries have terminated their BITs. India has terminated 58 of these bids during the last 2 years. A number of other states have done the same. Other countries have withdrawn from the ICSID Convention. Venezuela, Bolivia, Ecuador are examples. Yet another group of countries have been systematically clarifying and curtailing various provisions in investment treaties. The 2011 NAFTA interpretative note was one of the earliest efforts to clarify and limit the meaning of FET in NAFTA. The US implemented similar changes in its 2004 model BIT. Most recently, Canada has withdrawn from ISDS provisions of the proposed NAFTA 2. Further, developments at the European Union have been equally transformative. For the last 10 years, EU has been trying to persuade a number of its members to terminate their intra-EU bids. The 2018 ruling of the Court of Justice of the European Communities in Achmea is very important here. The court held that arbitration clauses in intra-EU BITs are incompatible with EU law, which has undoubtedly added fuel to the debate against ISDS and will likely affect numerous pending cases initiated under intra-EU and the Energy Charter Treaty. Brexit also adds another major wrinkle to these developments, and its effects are closely discussed and monitored in relevant circles. Paradoxically, while these efforts to address the shortcomings of the ISDS system has continued, states have continued to negotiate bids and mega-regional agreements such as CETA, TPP-11, RCEP, etc. Several dormant investment treaties, particularly those involving Islamic nations, including the Unified Agreement for the Investment of Arab Capital in the Arab States, and Organization of Islamic Cooperation's Agreement on Promotion, Protection, and Guarantee of Investments, have been rediscovered in a sense and are used to bring claims. That brings me to my next point, which really is the global reform initiatives to address the problems with the ISDS. The criticisms of the ISDS system have set in motion a major global response from the United Nations Commission on International Trade Law, or UNCITRAL, which has formed the UNCITRAL Working Group 3 in order to study possible reforms of the ISDS system. The Working Group 3 is a government-led and consensus-driven process where representatives of the 60 UNCITRAL member states, as well as any other observers, including European Union, ICSID, and a number of NGOs such as the ILI, get to comment on every issue raised if they wish. India is participating in this process too. The mandate of the working group, unfortunately, is somewhat limited and narrow, as it only wants to fix the problems such as inconsistency of arbitral awards or arbitrator bias through procedural devices. The working group is not supposed to deal with issues of substance, such as interpretation of FET. What exactly the working group is able to accomplish through this limited mandate remains to be seen. On the consistency issue, for example, working group's goal is to improve consistency and enhance predictability of arbitral awards, which in turn improves legitimacy of the ISDS system as a whole. Well, that is an admirable goal in itself. Achieving a full consistency, however, would be impossible given the working group's narrow interpretation of inconsistency, which comes down to inconsistent interpretation of the same or similar investment treaty provisions. When we know that there are 3,500 treaties and they have different language, they have different formulations. Competing proposals are on the table to address the inconsistency problem, as well as many others relating to selection of arbitrator, parallel proceedings, etc., which I alluded to earlier. These proposals will be considered in the next session of Working Group 3 in April in New York. On the one hand, some countries are advocating incremental changes, such as introducing some pre-award review mechanisms to try to identify and address possible inconsistency problems. On the other, the European Commission openly and systematically is promoting the idea of a standing court, which will have a first instance and an appellate level, which would presumably fix the inconsistency problem together with some other issues, such as arbitrator independence and impartiality. Given the narrow definition of inconsistency by the working group, however, I would think that little would be gained at this time by investing in developing such a mechanism. If we had a uniform multilateral investment agreement, this would have made more sense. The concerns with ISDS have also mobilized the ICSID Secretariat at the World Bank. In August 2018, ICSID released its proposed amendment to the ICSID arbitration rules. The proposed amendments try to address concerns relating to transparency, third-party funding, time, and costs. ICSID plans to put the proposed amendments for vote by the ICSID members on October 2019, which is very optimistic and more likely would happen in 2020. If approved in 2020, the new rules would go into effect in 2021. It remains to be seen how the proposed reforms would affect the system as a whole. Fifth, and my last point, so where is India heading in this context with the ISDS? India has terminated majority of its old BITs, but has started negotiating new ones based on its 2015 model BIT. In 2018, for example, it signed a new treaty with Belarus. The new treaty has an ISDS provision, but it also contains a number of safeguards to manage parallel proceedings, limit the applicability of FET, and eliminate MFN altogether. India is also party to mega-regional agreements like RCEP and India-ASEAN investment agreements, which will be used in the near future probably. With the ISDS provisions in place, India would have to be on guard to ensure its relevant civil servants are aware of the obligations undertaken in these treaties. The key is education and capacity building. You have to build capacity to play the game more efficiently and effectively. Whether bids are essential to attract foreign investment is also something that Indian economists need to study to help policymakers decide whether and how to shape and organize India's future BITs. This ends my presentation. Thank you very much for your attention.